Good afternoon or good morning. My name is Maria Bloyer from Advocates for Justice and Education, and I am thrilled to welcome you to yet another Special Education Thursday. For those of you who haven't noticed yet, I am not your typical host, Molly Whalen, but I'm hoping you'll have fun anyway. I'm here today with Yetta Myrick, who is going to be talking with me about aftercare, daycare, recreation programs, and all of those outside of school activities that families of students with disabilities, sometimes struggle to access. For those of you who aren't familiar with the Special Education Thursday model, this is just a short tidbit of information about a particular topic in the special education space. And today, because we have a repeat performer from Ms. Myrick, we're going to flip the script a little tiny bit. And even though it says I'm hosting, Yetta is actually going to do all the hosting after I ask the first question. So it'll be my turn to be grilled on this show. So I don't know how I feel about that. But so Yetta, welcome back to Special Education Thursday.
Thanks, Maria.
Thrilled you're here. Before I hand it off to you, do you want to kind of tell us about you a little bit and all of these things here on this slide? Because there's a lot there.
Yeah, there is a lot here. Thanks, Maria, for having me back again. And just for the record, because Maria is so modest, she is the Director of Programs and Outreach of Advocates for Justice and Education, which is DC's Parent Training and Information Center and Family to Family Health Information Center. So I want to make sure we got that information out there. And a little bit about me. I'm Yetta Myrick. I'm a parent, first and foremost, of a now 20-year-old at time that we are recording this, a young man diagnosed with autism, ADHD, and an intellectual disability. It was through my trying to access appropriate services that I originally got linked into Advocates for Justice and Education. And this goes way back to 2000, I believe, and in 2007, 2008. So probably even before Maria team, any of you who are now there, but that was kind of like my original introduction to AJE, trying to find appropriate placement and services for my son. And in that time, I started a nonprofit, DC Autism Parents, which is a 501c3 nonprofit organization here in DC that supports parents of children diagnosed or classified with autism, diagnosis or classification. And the main thing that we're doing right now, so at time of taping, we have suspended our support group, sadly, due to lack of participation. However, we do have a video series and a monthly newsletter that comes out, and we're looking at doing some other things in the future to support families. I also am a member of the DC Autism Collaborative, which is a public-private partnership. So AJE, DC Autism Parents, Children's National, and a host of other organizations, both community-based organizations, government organizations all across the city with an interest in supporting autism, specifically in early childhood at this time. That doesn't mean that we're not going to expand later, but really looking at making sure that that our children are accessing evaluations, getting linked into services, and so on and so forth. And that really is a place for us to bridge gaps and communicate with one another to really figure out, what families need. In addition, I also serve as a community member of the DC Developmental Disabilities Council. And that organization is, so technically, you are appointed by the mayor, but it is technically like quasi-government. It's supposed to be an entity that's working outside of government around advocacy for people with developmental disabilities in the district. And there are a number of government and community members, organizations involved in that work as well. And then the other thing that I have been serving as since 2016 is the Centers for Disease Control and Prevention's Act Early Ambassador to the District of Columbia. And in that role, I am basically supporting families and getting linked into free resources that the CDC offers to help families know what quote unquote normal development looks like, right? And are getting linked into services if there is a concern. So as you're hearing me explain all these things, there is overlap in what I am doing, and I'm very happy to be here. So I'm gonna ask Maria first question. What are we here to talk about today, right? And I will preface it your answer with this. I actually got an email this morning from a provider asking about childcare and where they can send a family actually before and after care was a specific question. So we're going to be talking about that, but I want you to like give the full breadth of of what's going on. What does this look like in DC, Maria?
Yeah, so that's a great question. So and it's funny, I'm glad you got an email this morning, because we actually did an intake today talking about, the ability of a student with a disability to access aftercare. So this is a thing, right? So what we're talking about is essentially all of the things in the community that aren't school, right? Where your student with a disability may want to be, right? Specifically, we're talking about daycare, aftercare, and a little bit summer recreation programming. But the legal framework for this conversation is really around, I want you to think like places of public accommodation, like movie theaters, that kind of thing. That's kind of the big high level framework. But what we're specifically talking about is access to daycare, access to aftercare, access to outside of school OST. That's a big phrase in DC. Everyone likes to say OST time, so out of school time. Access to that programming. And it's important for me to say all that and be super clear about it, because the legal framework for that time and those programs and that space is very different than the legal framework for the school day, right? Even though, for parents and families and kids, it might not feel like there's a magical difference when you go from one space to another space in like the legal reality. There is a big difference. So we are not talking about, school bell to school bell time while you're in the classroom. We're not going to talk about IDEA very much at all. And we're not going to talk about FAPE, which, as those of you who may have seen me before know that that's like a favorite thing that I love to talk about. But we're not going to do that today. We're going to talk about totally different laws and the ability of students with disabilities to access essentially out of school time activities. Does that make sense?
That makes sense to me. And just to clarify for folks who might not know these acronyms, so we're not talking about Individuals with Disability Education Act, which is the law that's basically governing the IEP, so individualized education plans or programs. I get confused. My son, full disclosure, is in a non-public placement. And so I'm like, in Maryland versus DC versus Virginia, I forget what there's plan program, get that confused. But you all get the gist. We're not talking about a 504 plan, and we're not talking about an ISFP, individualized service family plan, which you would get in the early intervention setting. We are talking about ADA, Americans with Disability Act. That is the law. So tell us more, Maria. Like I was like, if we're not talking about that, which is like what many of us know, right? And I'm gonna be honest and say, like, in my digging deeper into this, like initially it's like how does this work, right? Like I've heard some rumblings about how like with chat with after school like programming and IDEA. I've heard some things from people in Maryland about that. So I do want to like ask a little bit about that if we can talk about if we have time. But
Yeah.
I think really understanding the difference is going to make a huge difference for families, because I know it sure did for me.
Mhm. No, and I think you're right. And I think that, we spend so much time as the Parent Training and Information Center talking about IDEA and IEPs, that we sometimes forget to talk about the broader picture, which includes, like you said, the Americans with Disabilities Act, and also Section 504. I know Yetta said we weren't going to talk about 504 plans. We are going to talk about 504, though, which is really the first civil rights law that directly impacts individuals with disabilities. So it's kind of the granddaddy of all of this. So we are going to talk about that in the context of community access.
And I was going to say, not to interrupt you, can you
Mhm.
like explain the difference when we think about school in 504, like a 504 plan versus the section 504 of the Rehab Act?
Sure. So a 504 plan is just how schools do Section 504 of the Rehabilitation Act. So it's the same law, it's just a different context, really. And the thing that's helpful to remember here is that the Section 504 essentially stands for the proposition that a person can't be denied access to or excluded from a government program or a government benefit, essentially, that they are otherwise qualified for by reason of their disability. That's sort of the big idea behind Section 504. And then also, I mean, it's also really the big idea behind the Americans with Disabilities Act. You know, we're trying to provide equal access. And that's the phrase that I always think families should remember when we talk about aftercare. We're talking about access. We're talking about accommodations, modifications. We're not talking about appropriateness. Appropriateness is a word that comes from, you know, really the special education, IDEA, IEP space. When we're talking about access to aftercare programs, out of school time, we're really talking about um, modifications, accommodations that might allow a student with a disability to have access. And Section 504 and the ADA are essentially anti-discrimination statutes. Um, and I think that's something that sometimes families sort of don't always recognize when maybe their students being excluded from aftercare. So the way this comes up a lot for us, Yetta, and I'm sure you've seen this too, is maybe we have a student with ADHD who by the time they're in aftercare, you know, if they take medication, their medication's kind of worn off, or their cognitive load, or they're just kind of fried and tired, right? So we may see more disability related behaviors manifesting in aftercare. Well, disability related behaviors are part of the student's disability, right? And if we're going to exclude the student because of those behaviors, right, because of something connected to their disability, that's essentially a form of discrimination, right? And the ADA and the Section 504 say that, look, you don't get to exclude the child, okay, because of their disability, unless, okay, there is this unless, which is different also from, you know, IDEA, where the student is entitled to the education kind of no matter what. It's different in this context because unless including the student with a disability would require what's called a fundamental alteration of the program, which is essentially a big way to say big radical changes, right? Um, you know, and the law says that aftercare providers, recreation providers, daycare centers need to make what's called reasonable modifications to accommodate and integrate and serve students with disabilities. So for our kiddo with ADHD, you know, that may show up as, you know, this student needs a behavior plan. And it may be really informed by the behavior plan the student has at school, right? It may actually be substantially similar to, but it's in a different setting and a different legal framework behind it. And then the ADA and Section 504 also have a little bit of a different disability, a different definition of disability. Under IDEA, and I know everyone has seen me do this, if you've seen me do a training, there's a requirement that the student both have a disability, right? They have a disability that's recognized under IDEA, and there's a need for specialized instruction because of that, right? There's a nexus between the need for specialized instruction and the student's disability. That is not the standard that we're talking about here. So the standard for ADA and the standard for Section 504 is much broader, and it's a disability that broadly It's a really broad definition, and it says something that is a physical or mental impairment that substantially limits a person's major life activity, right? So there is going to be kids who, might not have an IEP at school, but would be eligible for protection under the Americans with Disabilities Act and Section 504, in aftercare, or in, at summer camp programs or in daycare settings. Um, does that at least make sense on like the high level? I know this was like the
Yes.
one thing and it turned out to be 10 things. Um,
It does. It does.
uh,
And I guess like my next question to you is, okay, so I now understand what the law is, right? A parent that's watching. What do I do about this, right? Like like I now know that like my child was kicked out of a center. They couldn't accommodate him or
mhm.
her, right? Like what's the recourse? Like what is the next step that I could possibly take? Um, because I'm feeling that my child has been discriminated against.
So let me just say, first of all, that I really recommend before you even get to that removal place, that we're in conversation with these places. That, one of the things that's very different about the ADA and Section 504 is that there's not a affirmative obligation placed on the provider, to go, look for students with a disability. So remember child find under IDEA, the student, the school has to go identify, locate, and evaluate all children who are suspected of having a disability. We don't have anything like that in this context. So the burden then shifts to the family, right? And the family then has to say, my child has a disability. This is what my child needs, to access your program. And then it becomes a conversation. Um, and this is why I think it's so important to talk about, what are reasonable modifications and this standard of fundamental alteration. Because it really is a conversation, and what's reasonable for some programs to do might not be reasonable for other programs to do. So it really is talking about sharing, planning, and figuring out a workable path forward. I think all, I think unfortunately, too often providers very, very quickly start saying, well, any change to how I do things is a fundamental alteration of the program. And that's just not true. You can change the way you do things and have it not be a fundamental alteration. Um, increasing your staff by one is not a fundamental alteration. Um, Making sure that you have someone on staff who's qualified to administer medication, that is not a fundamental alteration. Um, Instituting a behavior intervention plan or, a reward system for a student, also not a fundamental alteration. Not having peanuts, not a fundamental alteration. These are all doable things. And so what the student is entitled to is a reasonable modification. Um, so it's a little bit different, in IDEA. I kind of talk a lot about, they're entitled to an appropriately ambitious education. And that's it, this is the standard. And it doesn't matter if they're in a, in DCPS or in a public charter school or in a private school, and a non-public school, placed there through their LEA, local educational agency. It doesn't matter because that's the legal entitlement they have, right? Is an appropriately ambitious education. That's not the case here, right? It's a little different. It's you're entitled to reasonable modifications, and what's reasonable depends on where you are. So what's reasonable to ask a big program to do is different than what's reasonable to ask a smaller program to do. And I always like to just kind of flag that for folks because it really is a very different setting and it takes a different set of skills, and you're often doing a little bit more conversation and collaborating than you would be doing otherwise. Um, so does that part make sense? And then I want to
It
talk a little bit about
does.
this otherwise qualified part.
It does. And before you go to the next part, I have another question around the families that you have worked with, like, has there been a like best case scenario, or like the gold star example of how there was a challenge with a child care setting and they were able to make it work because they had a conversation? Like,
Oh, yeah.
who were the folks that were involved? Like, the thought I'm having is like, could the school team somehow be linked in if the child is in school with the center, and like helping to figure out what can be done to accommodate that child, for example?
Oh, that's a really good question. I love this question, actually. This is great. So let's talk about it in the aftercare context first. Um, in the aftercare context in DC, we've got kind of three different kinds of aftercare providers. We've got aftercare providers that are just part of the LEA, right? There's school staff and they're just there and it's something the school's doing. And I would say in that case, that's often when it's easiest to have the school collaborate and participate. And the connection between aftercare and the LEA is like the most obvious, right? And then sometimes and this is what you see in DCPS, you see a different part of DCPS participating in aftercare. So you have this OST program, who's maybe at the school site. That's actually also pretty easy because in the law, there's no difference. They're all DCPS. There might be some that's aftercare, we don't deal with that, or that's school, we don't deal with that. If you run into that, central office is a great resource, and the OST program they know what they're supposed to be doing, and they'll help you out there, I think. And then the other situation you run into sometimes is where there's contracted providers, and that is where it gets trickier, because those contracted providers are private operators who have some kind of relationship with the school or DCPS to be there. Now, that doesn't mean DCPS is, or whatever the LEA is. It doesn't have to be DCPS. It can be a public charter school. That doesn't mean the LEA is off the hook. As long as they're providing what's called substantial support, they're still obligated to make sure that the program that they're contracting with isn't engaging in disability-based discrimination. So the school really should still be your partner in making sure that you access aftercare and before care. So I want to just be real clear, sometimes there's some confusion about that, but most of the time when you get the right person, you should be able to really have a real conversation where you're having a conversation between the aftercare, whoever that might be, the school, and you on how to make this accessible for your student. So the best case scenarios I've seen, honestly have involved earlier intervention in the process where the parent discloses early and upfront, about what's going on. And maybe the aftercare provider talks about, what they're seeing and what they can do. I've seen it work really well around kids with ADHD in particular, because that does seem to be a space where, particularly at the end of the day, and when there's just a cognitive fatigue from being at school all day, we do see a lot there. But I've also seen aftercare programs, change their staffing model a little bit so that there's additional support. I've seen them do things like provide additional access to bathrooms or snacks. Students with diabetes are often able to store particular snacks and get assistance from aftercare in monitoring their blood sugar. So those are all things that I've seen work really well. But it is a conversation, and it's a little bit of a different kind of conversation than you might have had at the IEP table. And then I do want to talk a little bit about the otherwise qualified part. Otherwise qualified is just a way to say this is the program or a service that the student is eligible to participate in, right? So sometimes, for example, you may enroll your child in an aftercare program at a school, and then the aftercare provider says, well, we're not really set up to do that. That's not who we're intending to serve. that is, I don't want parents to ever hear that and think, oh, that means my child is not otherwise qualified and not able to participate in the program. Um, that is not the case. Otherwise qualified just means you're in the pool of people who this program is intended to serve. So if you're at elementary school X, and that's where you go to school, and the aftercare program is meant for students at elementary school X, you are otherwise qualified for that program, right? And you're in the right age group and the right grade group, you are otherwise qualified. Now it might be true that the program may never have been thought about serving students with disabilities, which I think unfortunately does still happen. But that doesn't mean that you're not otherwise qualified. Sometimes we get a little bit of confusion around that from both providers and families, because the provider will say, well, we don't really do that here. That's not a thing we do. And I want parents to hear that as not an excuse, right? You need to be set up to serve the full range of kiddos. Within, again, I mean, there's limits there, the fundamental alteration of the program being the limit. But you don't get to just say, we don't do that. Does that part make sense?
It does. So if a family is still having challenges, they've done their due diligence, they've had conversation, it's still not working,
Right.
and their child has refused access. Even if a parent has like tried all these things, knows the law, or they asked them to remove their child, what can a family do?
So this is the part that makes me a little bit sad.
Yeah, me too.
There's not the robust procedural and dispute resolution system for ADA and Section 504 that we have in IDEA. So there isn't like the administrative due process complaint. There isn't this automatic path to mediation. Families are instead really faced with, once they've kind of exhausted the internal, within the school building and within the staff, once they've exhausted that as a means of resolution, they're really stuck, unfortunately, reaching out to either the federal government office for civil rights in the U.S. Department of Education. We've got a link to them at the end of this, or the DC Office for Human Rights. I have had parents reach out to both of those organizations. OCR, which is the Office for Civil Rights in the Department of Education, has delivered some favorable decisions for DC families and families nationwide around disability discrimination. But it's a not insignificant amount of work to file that complaint, and it is slow. And that's part of the reason why I think that education and conversation around this are so important, because if you can't figure it out, between yourselves, it's really, really hard to get great relief quickly in the formal dispute resolution system, because you're really looking, the two easiest ways are the department, our OCR, and the Office for Human Rights. I mean, of course, there's also just plain old-fashioned civil litigation. Go sue them for disability discrimination, which is also a lot of work. That's a lot of work, and it might not solve your problem quickly. So I always like to really encourage families to do whatever they can to get it resolved informally, because the formal dispute resolution mechanisms are not quick. And also just accessing the formal dispute resolution system is one of the single most stressful things you can do in life, period. And if you're already having this conversation, you already have a lot on your plate. So adding more to it can be tough. But those are really your options. A lot
Is
of
there, not to cut you off, I apologize, Maria, but I'm wondering, is there any difference if you're dealing with childcare versus aftercare versus summer program? Is there a difference in who you reach out to, or is that like the overarching for all those things?
Oh, that's a good question, and I wasn't really clear. So my two examples, OCR and OHR, work for aftercare programs, right? If you're in a daycare program, okay, all daycare programs in DC are licensed. If you're in a daycare program, you can file an unusual incident report or access kind of OSSI's internal. OSSI is the Office of the State Superintendent of Education. They have like an internal grievance process that you can access and file a complaint there, and they can help the licensed provider, figure out what their rights are. So they can be very useful. Now, this is tricky though. So even though all providers in DC have to be licensed, there's this big exception. Okay. And that's for aftercare and before school providers and people who are primarily working in schools to provide care to students who are somehow connected to the school, right? So that means that summer camps, aftercare, and before care, unless those programs are also licensed, and they don't have to be licensed, they can be licensed if they want to be, but most of them aren't. That means you can't access the OSSI complaint dispute resolution, and it's a very informal process, but they can be very helpful also. But for a whole lot of families, it's not even an option because the program that they're in isn't licensed, because there's this exception. If you're associated with a school or if you're an aftercare or a before care provider, you don't have to be licensed with OSSI, which is not ideal. If we're talking about a summer recreation program, like through DPR does have its own internal process. I am unaware of any families who've navigated that successfully. Just want to be very transparent there. There may be families who've navigated that successfully. I have not met them, but it does exist, and I would love to be able to tell families more about it, but I don't know much about that. And I'm not aware of anyone who's had a great experience there. But also in theory, those are, federal programs. They are, the Americans with Disabilities Act and Section 504 do apply to them because those places do receive federal funding. So you do have this whole avenue of civil litigation, but no parent really wants to do that. And let's just be very clear. It's a lot of work. It's very expensive. It takes a very, very long time. And at the end of it, you still don't have childcare for the summer because you've been in court for 2 years instead of getting childcare for the summer. So you could go to work and, take care of your kids, take care of your family, and take care of your life. Obviously, I'm a lawyer. We have feelings about litigation. We like it usually. But I just want to be real clear. It is not a great solution in this space. Because it's really time sensitive, right?
Yeah. And I appreciate you being transparent about this. Because our children are small for like a certain amount of time, right? And if you're gonna be litigating for 2 years, like so many things could happen within the span of 2 years if you have a 3-year-old, right? Yeah. It's I think those of you who are watching at home, like you understand how complex and challenging this topic can be, and we're only scratching the surface. Before we get into resources, is there anything else, Maria, that you wanted to share that you think we did not cover?
Oh, that's a good question. There's probably a lot, and I've probably forgotten all of it. I would say the biggest things I really want families to think about is to assume that their students, are going to be able to access these programs. To start with that assumption of access. It kind of breaks my heart the number of families that I talk to who say that they never even tried to do this thing. They never tried to do aftercare because they just assumed their student wasn't going to be accepted. Or, it'll be a family and I'm calling them about an intake and we're talking about whatever the issue is at school. And, it comes up that they've been kicked out of 2 or 3 different aftercare programs. And the family had no idea that they had rights in that context. You do have rights. They are different rights, but that doesn't mean they aren't rights. Um, and, the local educational agency does have obligations there. And I don't want families to forget about that. The school has an obligation to make sure the folks they're partnering with aren't engaging in discriminatory conduct. And refusing to serve or failing to serve, students with disabilities is discriminatory conduct. And the only time it's okay to exclude them, again, is when there's this fundamental alteration. And that's a really high bar. Just think of all the different places in the world where a person with a disability can go and be. Um, you know, and that's not fundamentally altering a lot. Restaurants, swimming pools, those aren't fundamental alterations. So just think about that. Think about that kind of framework of public accommodation, the larger world. And I think that will help a lot. There is a very, very, very narrow, small set. I almost regret mentioning this, Yetta. There is a very small set of kids for whom this is an IEP related issue. Okay. I've been practicing in this area of law for 15 years, right? Yeah, 15, well, 16 years I've been practicing in this area of law. I have had one IEP and one kid where aftercare was directly connected to a question of FAPE. So there is a very, very occasionally, FAPE is relevant in this conversation, and very occasionally we're talking about IEPs. But that does not happen very often. So 99% of the time, I don't want families to think about IEPs because that's not the right framework for this conversation, except for very rarely when the IEP team decides that there is something about aftercare or some kind of out of school time that is necessary for the provision of FAPE. Very, very uncommon, rare. And that's not going to be the pathway to making sure our kids have access to aftercare. Right. That's just not going to solve the problem here.
Thank you for your candor, as always, Maria. I know you have some resources that you want to share if families want to dig a little deeper. So could you talk us through these resources?
I do. So for the childcare one, I really do want to flag this wonderful OSSI complaints. This is staffed by real people who care a whole lot. I've had a lot of families call and have good experiences with talking to them. So that's a good place to start if you're in a childcare setting. And like I said, some aftercare programs are childcare settings also. So sometimes OSSI does have jurisdiction and can help with that. mychildcaredc.gov is where you can find childcare. It is not the most practical resource for a lot of families because it doesn't really divvy up programs by capacity. But what it does do is tell you who's licensed and who's not licensed. And sometimes for families, that alone can be very, very helpful because that lets you know, okay, well, this gives me an extra lever, right? I can use, if it's an aftercare program that is also licensed, that means you have two ways to push them, right? You can push them through OSSI and you can also push them through the LEA and then just pushing them directly. So, more tools in your toolbox can always be helpful. But it is, My Child Care DC is a good resource. It does have a lot of providers listed. It's just sometimes not quite as useful as we want it to be, particularly around aftercare. As those of you who've seen me before or gone to a training with me, you know that I can geek out on things. This American Progress article is exactly, if you wanted a really comprehensive deep dive into this issue and you're thinking about getting your master's in public policy and education around disability rights, this is a great place to go. If you leave DC, childcare.gov has a great listing, good resources, good local links. And then OHR, which is what I talked about a minute ago with the Office for Human Rights. This is how you would file a complaint if you felt like if you felt like a young person with a disability or a child with a disability was being discriminated against. that's where you would file. I put both links there, one for you to understand kind of the process, and then one's the PDF for how to file a complaint. That process is slow. There's a significant backlog over there, but those are also passionate people who care deeply about the work they're doing. And they can also kind of help you move things along a little bit as well. So for aftercare, again, we have this voucher issue. Not the voucher issue, I'm sorry, the licensure issue. The reason I mentioned the voucher is you can only take the child care voucher if you are licensed. So that's a good way to tell if somebody's licensed. But you can also look at My Child Care DC. If you're a family who's accessing aftercare and your student attends DCPS, there's the OST office, the out of school time office, which can be a very good resource. And they can be helpful, and they are well aware of their obligations under Section 504. And they know fully well that, that the private providers they work with do have a obligation to not engage in discrimination, and that the LEA, as they are providing substantial support, is obligated to make sure that they do that. They know that, and they can kind of help you. And if you run into barriers there, of course, you can always call us. In the charter sector, unfortunately, it's piecemeal. I can't go through 50 charter options. The PCSB can be helpful as long as you make sure when you're articulating your concerns to them to frame it as this is an example of a charter school violating my child's civil rights. They may not be as capable of engaging with you and supporting you if you frame it as this is a private provider. You need to sometimes make the link clear to them. This is a charter school that has an obligation to make sure that things they contract with don't discriminate against my child with a disability. And that's what's happening, right? So sometimes they can be very helpful, but you need to be mindful of how you communicate with them, and just make sure you are explicit in tying it to the charter's obligations to your student. And a lot of schools have an in-house grievance process. They're all required to have one. But a lot of them that might be a helpful avenue for accessing, some dispute infrastructure resolution systems, some formal support. And then, of course, there's the U.S. Department of Education, which we talked about earlier, OCR. They will accept complaints. They're happy to accept complaints. It is a very slow process. We've supported families in filing OCR complaints around aftercare and daycare issues. And I think had reasonably favorable outcomes most of the time, but it's a very, 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 very slow process. So I always like to put a little caution there for families. And then again, if you're looking at camps or after camps or summer recreation programs, if they're associated with an LEA, the LEA rules all still apply, and you can access them just like aftercare. And if it's DC Parks and Recreation, they do have an internal system that is worth reaching out to. Does that make sense for all the resources?
It does. Thank you so much, Maria, for going through all of this. And so as you all can see, we're at the end of our Special Education Tuesday presentation. You can go to Advocates for Justice and Education's website, reach out to them if you have specific questions. Really excited to be here to host a little bit and talk about access to childcare, out of school time, et cetera, with you, Maria.